legal minds. By virtue of being a beginner in legal studies and a new student of law, this is one of the tutorial sessions you must never miss. By virtue of being a new student, one of the fundamental questions will be asked as you sit for your exams, and this is one of the questions and principles you can never escape. One of the questions you'll be asked is the determination of what the legal concept of law is. One of the questions you'll be asked is what the term law is. When I was in my 100 level, my learned professor Emily made a statement. She said that there is no general definition of law. From this viewpoint, you can see that law has not derived any particular and standard definition for its understanding. So therefore, for you to properly understand what the legal concept of law is, you must take a look at the revelations of different legal scholars from what they see law as objectively and what they think law should be subjectively. And for the purpose of this tutorial session, we would analyze different schools and theories of law. We will analyze the different views from different scholars that were able to define what law is and what law should be. And after that, we will give a summation of the general concept of law in light of these different viewpoints to understand what law is. You must take a look at the different analyses that have been delivered by these different legal scholars, jurists, and writers in what law should be and what law is. From the view of John Austin, who is the person who propounded the positivist school or the positivist theory of law, John Austin is a British philosopher who in his different works have been able to make us understand what law is from his own general understanding. He is the person who propounded the command theory because he defined law as not just written rules and instructions, but commands that are set by superior, given to inferior, and enforced with legal sanctions. A close examination of the works of John Austin was able to make us understand a view of what law can be, of what law should be. It doesn't just see law as something that is written. It doesn't just see law as mere instructions and rules. It sees laws as commandments and instructions. When you take a close look at the express provisions of the Nigerian Criminal Code, you can see from these express provisions that most of the laws that are provided herein comes with you shall not, you shall not. This is the backbone of John Locke's understanding of law, that laws are not just mere rules and regulations. They are commands, instructions that are enforced with legal sanctions. So therefore, in John Locke's view and perspective of what law should be, you can describe that law are a set of rules, regulations, and instructions that come in form of the commandment and are also enforced with legal sanctions. It is pure theory of law, which was propounded by Hans Kelsen and also another Austrian philosopher. In his theory, he was able to establish the ground norm principle because he sees law as not just specific rules that comes in form of commandments set by a superior as expounded by John Austin. He sees every law as a structure of rules that can be traced to an higher authority. So, in our understanding of what law is from the general view and perspective of Hans Kelsen, who propounded the pure law theory, we can say that law as structure of rules, structure of norms, structure of instructions, structure of regulations and commands that can be traced to an higher law until it is being derived from a ground norm, which is known as the supreme law. While this has been met with so many criticisms, it is however important to appreciate the importance of this specific viewpoints and perspectives. That theory is the natural law theory, which was propounded by Thomas Aquinas, Zeno, and so many other brilliant Greek philosophers. In their perspective of what law is, they were able to reveal that law are not just sets of mere written rules, but those specific rules and regulations that can be deduced from what is right or wrong. The understanding of law basically excludes the fact that it must be found in a written and codified document. The understanding of law is that as long as we can understand what is just and fair, as long as we can distinguish what is right from wrong, everything that prevents us from engaging in wrongful activities are simply rules and regulations, regardless of the fact that it is not written. So therefore, from the perspective of these important and brilliant Greek philosophers, we can say that law are those specific rules and regulations that can be deduced from what is right or wrong. Just like we can see in the case delivered by the court in Alco and Fagbemi, where adultery was a criminalized act, although this is not found in a written law, because of the fact that we can deduce from our general understanding and belief that adultery is not just. Adultery is an act that is wrong. So therefore, it should be criminalized, notwithstanding the fact that it is not codified. This is just like a backbone of this particular school of thought. So, from the natural law theory propounded by Thomas Aquinas and so many other Greek philosophers, we can see laws as rules, regulations, instructions, and commands that are not supposed to be written, but the ones that can be deduced and established from our proper understanding of what is right and what is wrong. Apart from this that we just analyzed, we also have so many other school of thought. We have the historical school, we have the sociological school, we have the functional school, we have the realist school, and so many other school of thought that tries to define what law is from their own personal view and perspective. All these are just for the major purpose of making you understand and appreciate the fact that there is never a substantial and accurate or standard definition of what law is or what law should be, as these different philosophers, legal writers, and scholars just tries to reveal from their own personal perspective what law should be. So whenever you are faced with an exam question that asks you to define what law is, apart from the fact that there is a dire need to give your own personal perspective of what law should be, you should also appreciate the views of these legal scholars. Thank you so much for your time. Do stay updated for more insightful nuggets and legal tips.